Good morning, everyone. Thank you all for joining us today. I know it's the second day, but we are going to do our best to make this as fun and interesting a conversation for you all. This is really a hot topic. I mean, I'm not biased as an international lawyer to say that at all, but it really is a hot topic these days when we're seeing growing global instability, a crisis of accountability, and an alarming rise in authoritarian influence that really is testing the strength of international legal institutions. I have spent most of my career working for UN-backed international criminal tribunals, so it's no secret that I'm a firm believer in the value and the power of international law. But I have to say that in the last 4 to 5 years, especially which coincides with the amount of time I've been living in Armenia, I have never been asked the question more often, does international law really matter? And does human rights, do they really matter? Does it even work? Which is why I'm even more excited to be the moderator on this panel today, because I don't have to answer the question for once. I can pose these questions to my panelists and let them carry the burden. But anyway, the consistent answer I would always give in basic questions like that is a very obvious yes. Of course they matter, of course they work. But to be fair, the cynicism is not unfounded. There is an important body of scholarship highlighting a growing trend of authoritarianism in international law, where powerful regimes are increasingly shaping, or rather weaponizing, international law to serve their own interests. And those interests are not always morally or ethically sound. This will often involve, for example, you'll see this with an overemphasis on the principle of sovereignty, regime protection, national security, typically framed as self-defense at the expense of core international principles, with the laws of war tending to be the most egregiously thrown out the window. And we can really now see nowadays how powerful states are pushing back hard against international accountability mechanisms. Countries like Russia using the veto power to wage an illegal war of aggression with impunity, or even the United States imposing sanctions on the International Criminal Court for issuing arrest warrants. But it's the smaller, more vulnerable states that really rely on these very mechanisms to protect their sovereignty and their security. Armenia has turned to the International Court of Justice and has joined the International Criminal Court in efforts to peacefully resolve and peacefully address serious grievances with some of its neighbors. Countries like Vanuatu and other small, tiny microstates are also going to platforms like the International Court of Justice to lead global efforts on climate change, because their very existence depends on somehow preventing rising sea levels from erasing them and wiping them off the face of the earth. For these countries, and there are so many more, the international rule of law it's not abstract, it's not a nebulous, cloudy thing. It's an actual, literal lifeline of defense, and it levels the playing field in a world that is tilting towards, dangerously towards the might is right principle prevailing. So the rule of law offers protection. It is not just about post-conflict justice. It's about preemptive credibility. It's about deterrence. It's about a framework in which sovereignty can be asserted without force. And that is a world I want to live in. But how does that work in practice? That's what we're here to talk about today. And for this, we are joined by 4 absolutely exceptional individuals whose work represents different facets of the global architecture of international law, from national prosecution to transnational coordination, and international institutional administration to strategic foreign policy, I could not dream of having a better composition for this discussion than the panel that we have right here, right now. So let's begin. I should stop talking. I just love becoming a co-panelist, but I'm not supposed to do that. My first question is for Madam Prosecutor General. Can I just say I love saying that because she is the first Prosecutor General of Armenia, female. She's the first female Prosecutor General of Armenia in an institution that is over a century old. So we're very honored to have you with us today, and it is my great honor to ask the first question to you today. In light of Armenia's recent ratification of the Rome Statute and its increasing engagement with international legal institutions, how do you see the role of international justice, not just in addressing past violations, but in fortifying and strengthening Armenia's sovereignty and deterring future aggression through the legal system?
Thank you. Dear participants of the Yerevan Dialogue, dear Madam Chair of the thematic session, my dear Sheila, dear all, indeed, ratification of Rome Statute is a legal milestone. It is a clear expression of Armenia's commitment to the principles of accountability, justice, and the rule of law, both domestically and globally. It is also a sovereign decision taken in the light of evolving security and legal landscape facing. International justice, through mechanisms like International Criminal Court, plays a vital role not only in addressing past atrocities, as you mentioned in your introduction, Sheila, but in actively shaping a more just and secure future. It's imperative to reinforce sovereignty also through comprehensive legal mechanisms and institutions. For Armenia, this engagement strengthens institutional resilience and reinforces the message and even manifestation that impunity is no longer an option for anyone and anywhere. A modern state's sovereignty is not only protected by its borders and armies. It used to, but now it's the main challenge. And it also needed to strengthen the legal mechanisms and institutions. Legal tools shape legal strategy, create security architecture to proactively guard against and respond to evolving threats. As Prosecutor General, and you mentioned first female Prosecutor General, I see it as our duty to ensure that Armenia does not only participate in international justice. I want the Prosecution Office be involved in active shaping and upholding the standards, integrating international principles into our prosecutorial practice, into our legal reforms and institutional culture. I want to mention that since ratification of Rome Statute, it was indeed, and I will repeat, a milestone in legal reform of Armenia. The Prosecutor General's Office undertook several steps. We want to ensure that we are in comply of the process. So we ensure the compliance of the framework, the legal framework. Then we started bilateral meetings and dialogues with our colleagues from ICC. We continue the capacity buildings activities, and we enhance for sure the bilateral cooperation with the Prosecutor's Office. And the evidence of my mention is our participation in Eurojust and active dialogue with ICC. which we continue now within the scope of Yerevan Dialogue. I want to mention that our engagement with international justice is not just about addressing the past, it's about safeguarding the future. It is a manifestation that Armenia stands with a community of nations that believes justice is the most powerful shield for peace, security, and sovereignty. Dear participants of Yerevan Dialogue, prosecution and prosecutors are at the forefront of the fight for justice, despite the significant challenges they are facing while fulfilling their obligations. It's not about Armenia only. It's an overworld and also including European partners' challenge. Public prosecutors navigate complex legal landscapes and issues, ensuring that prosecution is conducted in line with international standards. The commitment of the Prosecution Office of Armenia is vital and instrumental for preserving public confidence in law, justice, and which is more important, the upholding of justice. So, as you mentioned, Shayla, I was following your word that justice is not an abstract. It's not an abstract aspiration. It's a discipline. It's duty and direction. The law is compass and accountability is the path that ensure we do not lose our way. So Rome Statute and the broader framework of international justice remind us that legality must be the language through which the world addresses harm, resolves conflicts, and protects human dignity. That's the path of Armenian Prosecutor's Office as well. So let us be reminded that justice must not only be done. It's the main challenge of prosecution offices worldwide. It must be seen to be done, and seen boldly, independently, and fairly. This is the burden and the honor of prosecutors. So prosecutors, as the guardians of legality, continue to ensure that the force of law always prevail over the law of force. And I don't want to move on with these issues. I want to give more space for questions. I suppose we are going to have questions and answers, and I stand ready to address any questions you may have concerning the path of prosecutor's office within the scope of new challenges. I mean, both negative challenges and positive challenges as well. So I will stop here to give more floor to my distinguished colleagues. Thank you.
Thank you so much, Madam Prosecutor General. I dream of the day where I see Armenian prosecutors in the ICC courtroom, judges as well. I'm going to get the registrar. No, I'm kidding. We are extremely honored to also have the Registrar of the International Criminal Court here with us today. Also, I mean, when I was a student, I wouldn't even be able to dream of being in the presence of this kind of esteemed colleagues, but I get to now probe questions from you. Mr. Zavala Giler, as Registrar of the ICC, you are obviously deeply familiar with the operational demands of ensuring that justice is accessible and effective. What steps are the court and its states parties taking, and what further steps should they be taking to ensure that small and medium-sized states can turn to the ICC as a means of protecting their rights and preventing violations of international law?
Well, first of all, allow me to thank you and, of course, thank the distinguished panelists and the organizers, the government of Armenia. It is truly a privilege to join you all here at the Yerevan Dialogue as part of this panel on the global imperative of the rule of law. To reflect on what I think is one of the defining challenges of our time, which is the resilience of international law at the international legal order in the face of growing political strain. Now, the Rome Statute is an achievement indeed of precisely small and medium democracies around the world, who see the International Criminal Court as a rules-based mechanism to protect themselves and their citizens from the worst imaginable crimes. However, today we face a paradox. On the one hand, international law has never been more developed, has never been more codified, has never been more accessible. Yet, on the other hand, we're witnessing what I think is a disturbing erosion in its observance. But we should be cautious not to mistake what appears to be visible cracks in the system for its failure. International law is under pressure, yes, but that is precisely when its necessity becomes clearest. For small and medium-sized states, those without armies capable of deterrence or economies that are large enough to shape global policy, the rule of law is not just a matter of justice, it is a matter of survival. Institutions like the ICC were built precisely to uphold the idea that no matter how powerful, no one is above the law. And no matter how small, no state is beneath the protection of the law. Now, I'm addressing you today at a time when, and I hope we can agree, that the role of the ICC in upholding the rule of law is perhaps more critical than ever before. But it's also being challenged and threatened more than ever before. And we find ourselves at a crossroads. The ICC is under pressure, not only from those who would seek to discredit its investigations or sanction its officials, but from what I see as a broader erosion of respect for the rule of law. I believe the stakes are high, not just for the ICC, infrastructure that underpins peace and security in the world. Multilateralism was once the glue of the post-war cooperation and is now under stress. Institutions that were built on the ideal of multilateralism are being tested. At the same time, the desire for accountability, especially in the wake of atrocities some were witnessing, is not waning, it is intensifying. And the ICC stands at the confluence of both shifts that are happening right now. As the court's reach and its efforts continue to grow, as we continue to make strides in fulfilling our mission, who does resistance from those who seek to undermine international justice. Such resistance has included, as you were mentioning before, the implementation of sanctions against court officials by one state, the issuance of arrest warrants by another state against judges and the prosecutor of the court, as well as a highly disruptive and sophisticated cyber attack that targeted our institutional infrastructure a little over a year ago. I see the ICC as being, in many ways, the last major institution created during the multilateral zeitgeist of the 1990s, conceived not by great powers, but by small and medium-sized states, who precisely placed their faith in the law. We must not allow a return to pre-World War II logic, a time when aggression went unchecked, atrocities went unpunished, and the power eclipsed the principles and the imperative of peace. Rather, we need to protect the international legal order. The legal order that we have built over decades. And in fact, we need to continue to strengthen it. And the way forward, I believe, is twofold. First, we must resist fatalism. The erosion of respect for law is not irreversible. Many states have continued cooperating with the ICC, even when it's under pressure. The ICC is very much alive today, and it's functioning, and states continue to resort to the court. In fact, just a couple of weeks ago, Libya accepted the jurisdiction of the court under Article 12.3 of the Rome Statute. Our states parties and those states who cooperate with the court understand that standing with international law strengthens their own sovereignty. This is, in fact, a big opportunity. that is hidden in this crisis, and is the opportunity to renew and strengthen international law on the basis of more equal engagement from all states around the world, who are indeed more engaged than ever with international law and international judicial institutions, as we're seeing in the case of Armenia. Second, we must continue investing in legal institutions, nationally and internationally, including special courts and tribunals, not only by funding them, of course, but by defending them, defending their independence, strengthening their procedures, and ensuring that they remain transparent, fair, and accessible. Because the legitimacy and credibility of global justice must be earned every day. And in that regard, I think it's important to recognize that despite the current challenges, states continue to place their faith in the importance and necessity of the ICC and its mandate, as demonstrated by Armenia joining and becoming our 124th state party in 2023, as well as Ukraine, our 125th state party in 2024. This, in my view, reflects that the commitment to international rule of law, multilateralism, is there and is not dormant, but very much present in the minds of decision makers and societies alike. The guardrails of rules-based order, which protect smaller and medium-sized states, remain as essential as ever before. Just to finish, I want to highlight, international law is not a relic. It is a living framework. And while it may at times seem endangered, it is far from extinct, because so many continue to believe in its promise and are ready to work to uphold it. Thank you.
Thank you. So I want to start clapping, but we'll save that for that. I'm going to leave today with resist fatalism burned into my brain. I love that. It's a perfect answer to that question I keep getting. Does it really work? Does it even matter? It's true. We have to resist fatalism. I think seems a little bit more realistic than saying just stay positive. I like that. Thank you so much. My next question is for Mr. Shkrlets. I said that correctly because, yes. Eurojust plays a crucial role in judicial cooperation across EU member states, but also beyond. And Armenia last year became the 14th non-EU country to formalize cooperation with Eurojust. What does that mean in practice? What will that mean in practice, rather? And how can Eurojust's model of cross-border coordination and partner engagement be strengthened or replicated to support justice efforts in geopolitically vulnerable regions outside the EU framework, like right here in the South Caucasus?
Thank you very much, Madam Moderator Sheila, and good morning, ladies and gentlemen. Let me start by thanking for inviting Eurojust to this extremely important discussion today. The topic which we are tackling is of paramount importance for all of us, for our societies, because the rule of law is what our societies are based on. And when we speak about ICC, Court International Crime on one hand, and the national legislation and nationally defined conventional crime, if I may say so, we are actually speaking about the same elements, about the elements of the same rule of law architecture. And Eurojust is the glue that binds together the elements at national level, the prosecutors, the investigators who are at national level fighting crime and trying to tackle transborder crime. Perhaps before I go deeper in, just in 3 sentences, I describe what Eurojust is and what is that we do, because this is something that is also within the EU often shrouded with a little bit of mystery outside of the practitioner's area. The name suggests that we are a judicial cooperation agency for the EU. What that means is actually what the name says, because the criminal justice systems within the EU are very much national. So in order to tackle transborder crime, prosecutors from different countries, from different jurisdictions, need to work together under the rules of judicial cooperation, international judicial cooperation. And this is not always easy. You can imagine different languages, different legal systems, and so on. So this is where we come in as an agency, as a bridge builder. Our mandate is to actually support operational investigations and bring those practitioners, those prosecutors who are investigating crime, to actually come together physically, sit together and discuss crimes, discuss cases, discuss evidence available, exchange evidence, work hand in glove as partners. The idea started 20 years ago for the EU, and it has developed to quite impressive scale, I would say, because only last year we supported more than 13,000 such cases. So this is the core of our business. And I'm extremely happy to be today here in Armenia with my friend, Prosecutor General, and other colleagues from the Prosecution Service of Armenia, because there has been impressive progress in your country in respect of cooperation with us and with other jurisdictions. Because when we speak about cooperation with Eurojust, we are not really talking about cooperation with one European entity, but we are talking about the cooperation with all 27 member states' prosecution services and beyond. Because at Eurojust, the model of bringing practitioners together is something that is applicable across the globe. And this is precisely what we are doing with our outreach toward partners in non-EU member states. And I'm proud to say that presently we have 39 countries permanently represented by liaison prosecutors and prosecutors in The Hague. So that means that a family of 39 people meet together regularly. We have developed collegial ties, and fighting crime in those 39 countries is actually happening at the quality level which is totally comparable to the level which we have achieved within the EU. And I'm happy to say that Armenia, as it was already mentioned by our moderator, is the newest member of this family with an international agreement signed. And that's quite an achievement, because I think in recent 4 or 5 years, there's only been 2 signed agreements with Eurojust due to the complexity of the bureaucratic process, I may say, within the EU. But achievement is definitely there, and we are looking forward to soon welcome liaison prosecutor in our premises in The Hague, because that would bring totally new dimension of options for cooperation for prosecutors in Armenia. Now, in the world that we live, and we have heard about the challenges which are presented to the rule of law in form of pressures against judicial bodies, even transnational, international judicial bodies such as ICC, it is important to keep in mind that attacks on such institutions are not only attacks against the courts or specific tribunals. They are actually attacks against the basis of on what our systems are based on. Because the rule of law in our democratic societies is the cornerstone of everything. Without rule of law, there is no predictability, there is no legal certainty. And if there is no legal certainty, there is no economic prospect. And we have seen many times in the past that if the legal system and the rule of law disintegrates and decays, so do the societies. Sometimes this decay takes longer, sometimes it happens quickly, but it happens inevitably. This is why we need to keep in mind that preserving and protecting the rule of law is imperative that we all have to follow. And this is why we, as a European Union, for sure need to defend institutions such as ICC, but not only ICC, also the recently announced new tribunal for the crime of aggression, and all the other judicial bodies within our respective countries. And to conclude, perhaps trying to frame the answer to your question, what does that joining Eurojust and closer cooperation in this agency would mean for Armenia and Armenian prosecutors? Let me phrase it this way. By joining Eurojust, you're actually joining the international community of professionals, of professional judicial officials. This is not a political organization. It is very much hands-on prosecutorial and judicial organization. And by joining this community, also the prosecution service of Armenia will become stronger and will have better chance of fighting crime in Armenia and beyond. Thank you very much.
Thank you so much as well. I hope that, for anybody who may have been questioning it in the audience before or later when you watch a recording of this, this is what the building blocks look like. You know, when we ratify the Rome Statute or join Eurojust, and then the question comes to me, well, we did that, and what does that bring us? What has that brought us? They're all part of the building blocks. They build upon each other. Justice takes time. But without these integral parts coming together, and I'm sure that, you know, Eurojust and the ICC work together as well. So this is all part of the fabric, the threads of the fabric that together create that robust resilience that allow, you know, small countries like Armenia to defend themselves better and also promote the rule of law and the peaceful resolutions of disputes. So it's wonderful for me to be able to hear about it and have you all together at the same time. But now we're going to move to a foreign policy perspective, which was always in my blind spot until I moved to Armenia. And for that, we have Dr. O'Kale to enlighten us. Your work bridges legal analysis with strategic policy making in often volatile political environments. And you are also, I'm going to say it, a ninja, because you have personally endured and overcome unjust prosecution yourself. Trial in absentia, sentenced to 5 years, but then ultimately acquitted for your work on democracy and human rights. That's incredible. Your perspective is very, very interesting to me. How do you see the role of a major power, like, for example, the United States, in strengthening the international rule of law? How do we get them involved? And how can it be better integrated into foreign policy so that justice and accountability isn't just, well, they become, you know, tools of prevention and peace building, and not just this afterthought, post-conflict remedy type response?
Thank you so much, Sheila, for the nice introduction, and thank you so much for having me and for joining this fantastic panel. And it gives me a lot of comfort to know that these individuals are in the places that they are in. I mean, it's really assuring, because it doesn't just take command of the work that they're doing. It takes courage, and it takes integrity, and it takes a lot to speak, I mean, truth to power. And I'm now going to talk to you about the people who spoil the work of all those great individuals. Well, let me start. I mean, I work on foreign policy, and my organization, the Center for International Policy, it's half a century old, and with a mission of supporting peace and security and promoting progressive foreign policy around the world. 50 years ago, I mean, it was founded by diplomats who were against the war in Vietnam, and they were part of, like, the movement in the United States against the war in Vietnam. We think about security in a broader sense, that it's not just about arms and wars, it's more about the root causes of insecurity and what instigates that, and injustice is certainly one of those biggest threats to peace and security. Actually, I mean, my organization is 50 years old this year, and also in April, it was the anniversary of the 50 years since the end of the war in Vietnam. Unfortunately, there are many signs right now that we're going backwards, and there are things that have been achieved that are regressing. That doesn't mean, again, it's like we fall into fatalism, but it's also important to be aware what went wrong, what works, and what doesn't work. I was also feeling very optimistic and had a lot of comfort when I heard the opening remarks of the Armenian Prime Minister yesterday, when he talked about the peace agreement that they're drafting with Azerbaijan, and underscored that if ratified, it will be grounded in strong legal force in both Armenia and Azerbaijan. Because this is the guarantor of the durable peace. And for a long time right now, the reason why peace has been given a bad name and diplomacy is seen as a weak tool, because the elements that makes them strong are sometimes, and more often than not, are just dismissed in a way. And those elements are like clear and simple. In order to have a durable peace, you have to have accountability, reparation, and a legal framework that would garner and guard the implementation and enforcement of all this. But what would it take to have this legal framework and an effective functional international law, that international law becomes really effective and not just a suggestion, as a lot of people may be seeing right now? Well, it first, takes the fair laws, it takes strong institutions, and it takes individuals who are independent, protected, and have their own integrity also secured. And these three things are under threat right now. And there are several threats, and I'm just gonna mention the main three core threats to the functionality of rule of law and the effectiveness of it that we very much need. As you all said, I agree with everything you said. It's not limited to the ICC. It's not limited to issues of war crimes. It is well beyond that. Well, the first threat is selective justice and the inconsistency in applying the rule of law and international law all over the world. You cannot call the same war crimes or the same acts that happen in a certain country as genocide, but call it in other countries self-defense. A lot of people think of that as, and name it as this is hypocrisy of the international, leadership. I think hypocrisy is a euphemism of weaponizing the law and euphemism for enabling impunity. And this is not a side issue. When you do that, when you selectively apply the law, when you obviously don't treat what happens in each country, whether we're talking about Gaza, Sudan, Ukraine, Cyprus, Armenia, these are the issues that, is not just specified, because when you do it selectively, you undermine the law as an effective tool. And when you undermine the international law, particularly as an effective tool, you become in a weaker position. And again, if you think about all the panels of yesterday, every single issue that was mentioned had to touch upon this. Even the panel that was about trade and transportation ended up referring to the issues that are happening in Gaza, because you cannot ignore it, because it relates to that. And the second threat is basically, I think Osvaldo mentioned this, is the threat to the institutions themselves. When you issue sanctions for members of the ICC because you don't like their ruling, you are not just harming the ICC, you are harming yourself. And there is a very important distinction, because I heard this a lot, and I think it was even in the description of the panel, is this the small states and the big states. I tend not to think that way. There are strong states and weak states. And also strong states are not the states that have bigger armies. They're strong states that have stronger democratic foundations, rule of law, and fair representation of the people. And we've seen this. I can give you tons of examples, but you know this, that it is, might does not make right, all the time at least. So, and if you think that this would only happen in the threats to the small states, just think about three countries, Canada, Denmark, and Mexico, and what's common about them. And when you think about that these countries, even as a rhetorical threat, are subject to this, something that is unheard of. is really underscoring again the issue of the importance of the rule of law that is founded in strong institutions, because this is the guarantor that doesn't change when leadership changes in those countries. And the third one, and the most important, that I think the biggest threat to not justice, but peace and security globally, is corruption. Because corruption is what actually buys impunity. The increased power of the oligarch and the increased, allowance and enabling of corruption is a threat. When President Trump in February decided to suspend by an executive order the Anti-Corruption Act in the FCPA, and 3 countries acted immediately: UK, France, and Switzerland. And they formed an alliance and a task force that is like an anti-corruption task force. This is an example to show that understanding, first of all, these 3 countries were able to do that and had the strength to do something like that because they are strong domestically. They have their own strong internal laws. And because you cannot safeguard international law when your own domestic laws are shaky and are not really on solid ground. So looking at that and seeing is like those countries acting really quickly and fast is a good example of what we need to do. And instead of admiring the problem, is actually finding solutions to it. And I think it was just like, it tells you also the capability that a lot of countries have in order to do something when they want to do something. And I think it's just, I would disagree with the description of like the conferences like navigating the unknown, because the people here, the leaders, the policymakers, they are not the ones who are navigating the unknowns. The ones who are navigating the unknowns are the civilians in Gaza who don't know if they're going to live tomorrow or not. Are the people in Sudan who are not sure are they going to be killed or die by starvation or by bombing. People who are navigating the unknown are like Dr. Hajar, who is the doctor in Gaza who found out that her children were bombed and her house were bombed and her children was like burned alive. This is what it means to navigate the unknown, the helplessness. But the people here, it is simple. As the foreign minister of Armenia said yesterday when he first saw, he said, I'm going to say it simply because it's simple. We have tools, we are able to stop it. We have laws that govern and regulate the use of arms, regulate the ways of like war, and we have the choice to stop it. And it's not helplessness, it's not unknown, we know, but it's a matter of not knowing. It's not about knowing, it's having the political will to do it. And thank you.
Thank you so much. Thank you so much. That you really speak to the activist in me, and I'm really glad that you also speak truth to power on very important issues. We have 6 minutes, but I have to ask one question. I can't help myself, and I will let all panelists answer it if they would like, but I'll start with you, Nancy, because it piggybacks off of what you just said. Small states versus, I guess, big states, not the right way of looking at it, better to look at it by strong states, weak states, right? I agree. If I think of, like, how can we convince these major powers to do the right thing, okay? For example, the situation in Rwanda, DRC. Rwanda is a small state, but it's much more powerful and has invaded DRC and is committing all kinds, the Great Lakes region is an absolute mess. And the Trump administration has gotten involved, but in a transactional sort of way, they are getting involved in peace mediation and trying to reinstill the law and order, but with an expectation of return. is this okay? Like, do you think that maybe that's a solution to reach the moral ground of enforcing the rule of law, but there has to be something in it for the power? Or are we doing it wrong if we do? Do you see what my question is?
Yes.
Yeah. Like, I have an ethical dilemma with it, but at the same time, if it's a means to the right end, is it okay? What do you think about that?
Well, I mean, thank you for this excellent question. And just to be fair and clear, the transactional approach to foreign policy did not just start with Trump. I mean, it has been mostly the way of the United States, and the approach particularly towards countries, I mean, it's like the what we call, like, for lack of a better word, weaker countries. And I think it's just like there are issues that are problematic with that, is like in the understanding that the military solution is the solution. That, again, like, might makes right. But the biggest problem of like this approach to foreign policy, it makes all the right calculations sometimes, but it factors out the people. It is government to government, is thinking about, is like the leadership, and mostly the current leadership, without making dues like what would happen is this particular leadership goes away. And that what happens eventually if there's no justice, if there's no peace. And we've seen it in many places. We've seen what happened in Syria and other places, is these regimes look very powerful. They look in control, but they're super fragile, and their fragility surprises us every single time, although, I mean, we talk about that. So yes, I mean, it's like, is it important to have and engage with those leaders? Yes, it is, but it has to be through transitional justice. It is not possible to guarantee durable peace when you think about past atrocities and violences as water under the bridge. It doesn't work. Thank you.
I mean, the question is not strictly relevant to each of your positions, but if you have any insights on the question, not necessarily just in that case, but in navigating cooperation with states and maybe conversations about, well, what's in it for me if I join? I don't know, if you want to touch upon it, but I'm not going to insist.
Yes, absolutely, I would like to, because it's, I think it touches again on a core issue. And as I said before, the rule of law is the cornerstone for everything. And it's not only a principle, because EU, as imperfect as it may be, there is something that I would like to highlight, is that with Lisbon Treaty, the rule of law is actually become a value of the European Union, a value which is a basis on which the EU is composed. So it is more than just a principle, it's a value. And when we speak about cooperation in cases that Eurojust is handling, I think the national authorities are usually motivated to provide cooperation because they see their own interest in it, if I may say so. Although I firmly believe that rule of law is not a commodity, should not be commodity, should not be traded, because it's a principle, it's a value, it should be applied. But also in real life, there are all kinds of limitations. In international judicial cooperation, anybody who has been involved in that knows that there are, of course, limits to it. And I will not try to fool you by saying that Eurojust is a magician, is a magic formula which solves all the problems. It's not. We build bridges. We make connection between the requesting country and executing country, or the countries who conduct parallel investigations. We make bridges between the people who are conducting those investigations. But we do not have any power on them. We cannot command or tell national authorities what to do or what not to do. So when we provide and we promise support to our colleagues from our national authorities, what we can guarantee is the effort, not the result, because the result is on the execution country. But there is an important element which is built in the system, and I think this is the beauty of it. It's the peer pressure, because being a member of this community, if my authorities are not responsive to judicial requests, I have to explain that to my colleagues. And it's not easy. And for a certain time, I can use my credit But after a while, this credit will run out, and I will have to go back home and I will have to address the issue with home authorities at adequate level. If that means that I have to address it at the highest possible level, at the Prosecutor General's level, I will do so. And this is what all the colleagues who are members of Eurojust will do. So this is the development which we have seen in the EU in the last 20 years, a little bit more than 20 years. And it may not look like much, but in practice, it does a bigger difference. And as I said before, if we manage to tackle this trans-border crime, which is borderless, and let's be honest, the organized crime groups are operating without any limits, without any hindrance, without any problems connected to jurisdictions. If we, which are linked by and limited by all those limitations, wish to tackle that effectively, no state can do that on its own. We need to work together. We need to work together as one. And this is the tools we have, and we should use them. And I think they do make a difference. Thanks.
Well, I'm going to selectively answer your question because I don't want to, let's say, it would be a little bit outside the scope of what I can say. I think that when leadership has a moral component, it's stronger. And when leadership is transactional, it may expose double standards that may weaken that moral component. And there is a lot of strength in the soft power that moral leadership gives to a state, a nation, a politician. I also think that sometimes some positions may amount to shooting yourself in the foot. Because all states at some point have an interest in rule of law and accountability of some kind. And when you delegitimize the institutions that are dealing with accountability and with justice, then when is your turn to ask for that accountability and that justice? Or when is the turn to ask for accountability and justice for other situations? Then those will also be delegitimized. The ICC is operating in a number of situations that touch the broad political spectrum of world politics today. And the kind of actions that are being taken against the court are not only affecting its ability to work in one situation, are affecting its ability to function properly in all of its situations. And that is detrimental, even for those powerful states that want to pursue specific transactional, let's say, even aims. So I would hope that there is, I think, a turn towards a more moral leadership in the world. Thanks.
Thank you. I would like to add some points to what my distinguished colleagues has already told. One practical issue I would like to mention that we have already started our communication and collaboration with Eurojust actually, and we are in the final process of sending the liaison prosecutor to Eurojust office, and it will be the end of the year that we will finalize the process and will be at the office. But the bricks, as you mentioned, Sheila, are there. We are already in daily communication with our colleagues and on very specific international criminal acts. I mean, transnational crimes, money laundering, and financial crimes, and etc. And it's very strong tie and bonds between Armenia and the Eurojust. And the second issue I would like to stress, it's the morality component. As my colleagues already mentioned, it's the essence, but I will add the integrity part. Because when we are talking about morality, for example, in judiciary, it is the matter of integrity. It's the behavior when no one is watching. And corruption issues, we were discussing with my colleagues yesterday, is a modern way of slavery, as I used to say to my students at Yerevan State University when we were discussing the integrity issues and corruption issues. And impunity both domestically and globally, it blooms within the scope of corruption. So if we want to improve the situation, within the judiciary, for example, in our country, we need to start fighting the corruption. So maybe there is no very strong linkage between when we're talking about international criminal codes and, for example, the corruption issues and integrity issues within the country. But it's the ground of trust. And the trust is the essence for prosecutor's office to collaborate, and the trust is the ground and platform for the ICC to deal with the country. So it's two main points I would like to add to what my colleagues have already said. Thank you.
Thank you all. Thank you all for your patience. And I do apologize that we won't be able to take Q&A after all. We're here to answer any questions you have anyway. Sorry, I know. This was my dream panel, but my dream of having Q&A didn't come true. Something had to give. I'm sorry. But thank you all so much. I really loved this conversation, and I'm really honored that I was able to moderate this amazing panel. Thank you all.